Welcome to We Learn Virtual Learning Network. This is session number 6, Basic Features. Topics which we are going to cover in this session are Government of India Act 1935, Constituent Assembly, Essential Feature, Emergency Provisions, Federalism, Relative Flexibility. Coming towards the first topic, that is the Government of India Act 1935. The precursor to the Indian Constitution was the Government of India Act of 1935, usually referred to as the 1935 Act. The Indian Independence Act 1947 held that until a new constitution come into force, the 1935 Act would be the constitutional law of India. The 1935 Act was the product of the report of the Joint Select Committee that was discussed in the British Parliament before finally receiving the assent of the Queen on 2nd August 1935. Next is the Constituent Assembly. For the purpose of writing a constitution, a Constituent Assembly was convened. The constituent had to live up to the aspirations of the people who had been exposed to several countries for injustice, social exploitation and discrimination, as well as 2 centuries of colonial dominance. The motto with which the constitution making exercise was undertaken was consciousness rather than the majority principle. Renowned members of the assembly included T. Krishnamachari, Dr. B.R. Ambedkar, Aladi Krishnaswamy Iyer and Gopal Swami Iyengar, Salyama Prasad Mukherjee, J.B. Kriplani, Vallabhbhai Patel and Patabhi Sitaramya. There were to be 381 members in the Constituent Assembly. They represented the various political parties and belonged to the Congress Party. The provisions of the Constitution were extremely debated upon the several committees that were formed for the purpose before being presented to the Assembly for its consideration. The final document, after making amendments to the draft Constitution, was signed on 26th November 1949 and the 2 months later it came into the force. Next are the essential features. The essential features of the Constitution of India are as follow. The Constitution is supreme. The sovereignty of India cannot be surrendered or pledged. India is a republic and not to be turned into the monarchy. Democracy is a way of life than merely providing for adult franchise. Secularism and independent judiciary are 2 predestinations of the democracy. The preamble of the Constitution declares that the people of the country are the sovereigns. The sovereignty of the country cannot be pledged. In the preamble, it is also stated that the country shall be republic and shall adhere to a democratic form of the government. Next is the Union of States. An important feature of the Constitution is that it has constituted India as a union of states. The provision for admitting new states would also be understood in the context that some of the princely states were yet not ready to be the time the constitution would come into force to become the part of India. The constitution provides for creating new states and admitting new territories. Next are the fundamental rights. The fundamental rights provided for in the constitution could be summarized as right of equality, right of freedom, right against exploitation, right to religion, cultural and educational right, and the right to constitutional remedies, the right to poverty. The right to poverty was made a legal right through the 44 Constitutional Amendments Act and is hence not a fundamental right now. In the larger interest of the country, the property belonging to any person can be acquired by paying a compensation. The fundamental rights are enshrined in Part 3 of the Constitution, and their implementation is guaranteed by the Supreme Court. Some of the fundamental rights, it might be noted, are applicable only to the citizen of the country and not to the foreigners. Article 20, Article 21 and Article 22 are however applicable to all. Now coming towards the right to freedom. The Constitution also ensured the right to freedom under Act 19 to 22. Article 19 guarantees the right to freedom of speech and expression, right to peaceful assembly, right to form associations, right to visit and reside in any part of the country, and the right of profess and practice one's religion. Article 20 guarantees that no person shall be punished on the basis of law that are enacted after a crime has been committed. Article 14 guarantees the right to equality before the law and the right to equality protection of the law. Article 15 guarantees protection from discrimination on the basis of religion, race, caste, sex, or place of birth, and provides for equal access and thus the right against discrimination. Article 16 provides the right to equality of the opportunity in employment. Next, coming towards the descriptive principles of state policy. The descriptive principles of state policy are an adaptation from the Irish Constitution. These are broad guidelines which have to be borne in mind while enacting laws and in implementing them. The descriptive principles of state policy prescribe that all the states shall ensure adequate means of livelihood for all, distribution of wealth and control over it, rather than concentration in the common goods, equal pay for equal work for both men and women, non-abuse of the health for all workers, the protection of children of the country from the exploitation and their growth in the atmosphere of freedom and dignity. Next are the fundamental duties. The fundamental duties enshrined in the Constitution are intended to obligate all the citizens to strive for the common benefit of all. They are expected to accord respect to the Constitution, the national tricolor, and the anthem. The citizens of the country have a duty to protect its resources, both natural and material, and work towards higher level of achievement. Next, coming towards the union: executive, legislature, and judiciary. Three organs of or branches of government are legislature, executive, and president. So coming towards the legislature, these are: at its independence, India chose to adopt a parliamentary form of government. In such a form of government, the president is the head of the state, while real executive power is exercised by the head of governance, that is, the Prime Minister, in association with his councils of members, all of who are collectively responsible for the parliament. And coming towards the executive, in our country, the legislature and the executives are drawn from one another, while the judiciary is an independent body. The legislature comprises of House of People, that is Lok Sabha, Councils of State, and the President of India. A member of Union Council of Ministers has necessarily to be a member of either of the lower house, that is the Lok Sabha, or the upper house, that is the Rajya Sabha. Next is the President. Both the houses of parliament and the legislature in the state elect the president by means of a single transferable vote. The office of the president, its functions, power, tenures, method of election and re-election, impacted, and the qualification required to hold the office are included in Articles 52 to 62. All activities of the state are carried out in the name of President, as the executive power is vested in the President. Now coming towards the Prime Minister and Councils of Ministers. The Prime Minister is the head of government and presides over the meeting of the Union Council of Ministers. It need to be kept in mind that there is a difference between the cabinet and the councils of ministers. The council of ministers is collectively responsible to parliament. The activities of the ministers are brought under scrutiny by the opposition during the 2-hour-long question hours at the beginning of each day of the session in the parliament. Now coming towards the legislature. Legislature is legislature, the Indian Parliament is the supreme law-making body of the country. It is a bicameral legislature as in the United Kingdom, the United States, and several other countries. The upper house is known in Hindi as the Rajya Sabha and in English as the Council of States. All states of the Indian Union do not send an equal number of representatives. The lower house of parliament is the House of People, better known as Lok Sabha. Now coming towards the judiciary. The third and very important organ of government is the judiciary. The highest court of appeal is the Supreme Court. The Supreme Court has both appellate and original judice. So do the high courts in the respective states. The Supreme Court is the custodian of the Constitution. Laws enacted by the legislature can be declared invalid by the Supreme Court if it is of the opinion that they are not in conformity with the provision of the Constitution. This power is known as the power of judicial review. The President of India appoints all judges of the Supreme Court and High Court and the Chief Justice. The Supreme Court and the Parliament have on occasion entered into the tug. Next, coming towards the emergency provisions. First is general emergency. Emergency can be proclaimed when the security of the country is under threat or is under the danger of the threat from hostile countries during time of war or external aggression or armed rebellion. Emergency was declared under this procedure for the first time in the wake of the war with China in October 26, 1962. The most continuous and abusive emergency provision is Article 356. If the President receives a report from the Governor of the state stating that the constitutional machinery was broken down or that the administration of the state can no longer be carried out in accordance with the provision laid down in the Constitution of India, an emergency can be declared in that state. The first instance of dismissing a state government by invoking Article 356, even while it continued to enjoy the conference of the state legislature, occurred in 1956 in Kerala when the communist government of the day was dismissed. It generated a major controversy and it was argued that it was a wrong decision as the government commanded a majority on the state assembly. Next is the financial emergency. Financial emergency can be declared under Article 360 in conditions in which the financial stability or credit of the country or any part of the country is threatened. In the 44 Constitutional Amendments Act of 1979, such as proclamation needs to be approved by the both Lok Sabha and the Rajya Sabha within 2 months from the date of its proclamation, or if the Lok Sabha is at the time dissolved within 30 days from the date of its constituted. Next is the federalism. At the time of independence, the diversity of the country was such that the constitution maker thought it fit to have a strong union government within a federal framework. For more than a decade and a half after independence, the center and the state had almost no problems. The balance in relations titled more in favor of the central when Indira Gandhi was the Prime Minister of the country. Next is the center-state relations. The center-state relations are divided into the two parts, financial relations and the governor's rule. So coming towards the financial relations. Another continuous issue is the sharing of financial resources between the center and the states and allocation of central grant to various states. While states have long been demanding the allocation of larger portion, a new proposition suggested is allocation on the basis of the performance. Next is the governor's rule. Yet another point of difference is the imposition of governor's rule on the state and his role while in office besides that of his abrupt removal. Governors are generally appointed with the concurrence of the Chief Minister of the concentrated state and the Sarkaria Commission too. Next, coming towards the relative flexibility. The institution provides room for amendments. When a constitution is amended, it is expected that it would bring a change for the better. Article 365, together with other article, empowers Parliament to make amendments to the constitution. The amendment procedure laid down in the Constitution is both rigid and soft for different articles. Two of the most vehemently contested aspects were one on the authority of Parliament to effect amendment itself to any article of the Constitution, and two on who holds supremacy of decision over an amendment. The Supreme Court has the power to decide whether an amendment to the Constitution indeed were against the basic features of the Constitution or not. So that's all for this session. Following are the questions based on this session. Explain it's a right issued by the court to the state authorities to produce the body or person before the court. Next is explain decision based on the consequences. So that's all for this session. Thank you. Happy learning. We learning.